So how do you do a good background check? Well, it starts with that employment application and whatever other paperwork you get from your applicant. And from that, we'll take their name, date of birth, social security number, and their address history, and we'll run them through a database. And some people call it an identity verification or social security verification. What it really is, it's a database that's got the information from credit bureaus, driver's license files, and other proprietary sources. And it's got a pretty good address history and name history for your social. So if you've been married, my wife, and what she calls the good old days, was Christy Gable before we were married. And don't laugh, but any bad offenses, any of the bad things she did before we were married, won't show up if you just search Christy Coffey, because all the court's records are indexed by name and date of birth. I know we watch CSI and all that stuff, and they just type in, the guy's, shoe size, and here comes everything that ever about him, and and it's all in full, high definition color and all of this. It just doesn't work that way. All the court's records are indexed by name and date of birth, and so you've got to have a good name to search, and plus then the dates of birth. And so we may see that somebody's playing with their date of birth. The former offenders who are trying to hide their history, they know how to do that. They know how to kludge up the system so that the records don't show up if you search it wrong. So you see people, John Michael Smith will apply as Mike Smith, and you'll never find that record. Or they'll switch their month and their day of birth. So instead of saying they were born on January 5th, they'll say they were born on May 1st. Same year, so the age looks about right. Then they can just harmlessly say, oh, it was just I transposed those, sorry. But if you don't have a good date of birth, you're often going to miss records in some of the court systems. So we take that ID information, and then we drive it over to glean out of there the associated names that we should be searching. Verify that the social security number was issued after they were born, because we see that a lot with, especially undocumented workers, where they're using a social. They were born in 1980 and the social was issued in 1975. That probably is a red flag for you. And then a good address history, because if anybody knows where you've been, it's the people you owe money to, and they report it to the credit bureaus, and it shows up in this database. So we can really tell where we need to go research. So we start with that identity research, and then we go to the state and national. We call it a multi-jurisdictional database, because calling it a national database is really overselling it. But we run their information through the database, and then whatever records may show up out of there, we go and verify them at the county courthouse. So that's how we prevent reporting expunged records on people. Or very often what we find is the state's database is incomplete, and maybe it shows that this guy got probation, and we go to the courthouse and we say, well, let's see what happened here. And the court's records say, well, he did get probation, but it was revoked and he was sent to prison. And so we know we need to verify those records in any database, whether it's a state or a private database. And then we also take their identity research and we search all the jurisdictions where they've lived previously. So we go to look in the counties where they've lived, worked. We looked at their application and we say where have they lived and worked and attended school. Plus we look at their identity research to identify those counties. And then finally, the federal research. And if you're going to cut money out of your background screening budget, because none of us have unlimited budgets and everybody's got their own considerations there, the federal would be the where I would cut. Your best money is always at the county level. That's where you're going to find the overwhelming majority of your records, and that's you spend as much money as you can doing county searches if you have any kind of budget concern. But then you get all those verified criminal records from those jurisdictions, and they go in your background screening report. That's a good criminal background check. Now there are a lot of other services that screening companies offer. Searches for wants and warrants, civil records researches, which may be appropriate for certain positions, things like that, certainly employment and education verifications. There are a lot of other services, but these are the core ones that we see most in a criminal history background check. Now the Federal Fair Credit Reporting Act is what governs background checks. And there are a lot of responsibilities on me as the background screening firm related to the background check. But there are a few that the employers need to know about that are your responsibilities. The first is that before you ever even think about ordering the background check on this individual, on this applicant or current employee, you've got to disclose to them on a separate document used exclusively for that purpose that you're going to procure the background check. It can't be the small print at the back of your employment application. It's got to be a separate document used exclusively for that purpose. So look at your document. Do you have all kinds of other information on there? Waivers of liability. Say, I see that a lot where people put something that says, if the background check's wrong, you agree not to sue us. You can't have that on your disclosure form. The Federal Trade Commission has been, and that's who governs this, has been really explicit that the law says it can be used for no other purpose. So that's what the disclosure document's got to be. And then you also have to get their written authorization to procure the background check. That can be electronic under the e-sign Act. They can do it electronically in your applicant tracking system, but they, most companies, what they do is they include it on that separate document, so that they've got this document where you're disclosing to them that you're going to procure the background, and then they're signing it and giving it back to you, so you've got proof that you made the disclosure. And the Federal Trade Commission has okayed that process. That's the only other thing that can be on that disclosure document is the authorization. So that's before you run the background check. So you order the background check, the background screening comes back and tells you this guy's an axe murderer. Well, before you decide not to hire this axe murderer, which really, let's face it, you've made the decision and you know what your policies are, but before you make that decision official, you have to give them a copy of their report and a copy of their rights under the law, which is a Federal Trade Commission prescribed document. And it's called a summary of your rights under the Fair Credit Reporting Act. And your screening company should give it to you when you sign up with them. That's our obligation. But then it's your obligation to give them a copy of the report and a copy of the rights under the law. Now, practically, if he's an applicant, you probably don't want to call him back into your office and say, hey, I understand you killed 3 people 10 years ago. We're not going to hire you. That's probably not a good conversation you want to have. So most employers will mail this stuff to the applicants, and they do it and they send it by mail, and then just wait a certain amount of time for them to make sure that they think the person's received that letter. What we recommend is sending that first letter certified mail. And now with certified mail, you can go to the Postal Service's website and just put in the tracking number, and it'll tell you when it's been delivered. And so you know exactly when they've received it, because you don't want to make that decision, or at least put it in effect, until they've received these disclosures. So once they've received the disclosures, you've made the decision, I'm not going to hire them, or I'm going to hire them for a different position. Maybe you see their driving history is a little questionable, and so we're going to put them on the dock and let them work on the dock for 6 months and see what their safety performance is before we put them in the truck. Or we're going to consider them not for a senior accountant, which is what they applied for, we're going to make them an accounting clerk because just their references weren't that strong. Something like that. Anything like that, they need to get that disclosure before you make a decision. Then once you've made the decision, and sometimes the decision is we're going to hire them without any negative adverse action, and you're done. But if you make a decision and you say, I'm not going to hire you, or we're going to consider you for a different position, then you have to give them notice, a second notice saying, here's what we're doing. This is the adverse employment action we're taking. And most of the time we're just not going to hire you, or we're going to withdraw our contingent offer. And you've got to give them that notice. And that second notice has to also have my information, the background screening company's information, how they can contact me if they want to punch somebody in the nose. That's us. And it tells them how they can. And the interesting thing is the first letter, the first notice, tells them their rights. You've got a right to dispute this information. But under the law, there's no obligation that with this notice you tell them who I am, where you got the background check from. So if it's not clear from the actual report, there's no obligation to do that. What everybody does, and what makes sense, is when they give them this notice, they also tell them how to contact the background screening company. So if there is an error, which is depending on the screening company may be common, and other screening companies are extremely rare, they can dispute it, and they can get it corrected if it's really wrong, and you don't lose a good candidate, and they don't lose an opportunity because of some error someplace. The other thing you need to understand as an employer is that the Fair Credit Reporting Act limits what a screening company can report to you. I can only report non-conviction information for 7 years after the disposition of the case. So what that means is like a deferred adjudication, which in Texas means the person's entered a plea of guilt or admitted responsibility for the offense, or at least said pled no contest to the offense, and agreed to serve probation. And so often they may get 10 years probation. If they keep their nose clean for 10 years, the case is dismissed. So 10 years after or 7 years after they complete probation, I can't report that case any longer. I can only, even though they admitted they did it, no matter what it was, I cannot legally report it to you 7 years after they complete their probation. Even if I see they lied on the application, it cannot be reported to you. And so you need to understand that, because if they're honest with you, you may have people who said, yeah, I had a case and it was dismissed 8 years ago, and your background check comes back clear. That may be the reason. It may simply be a fact of what's legally reportable, and they can't, and your screening partner can't tell you what it is.